All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
I'll be seated. All right, good morning. I am Chief Justice Sarah Stewart. It's really great to see all of y'all out there. I want to thank Dr. Fritsch and his team for having us. We've had a lot of fun, and your school is beautiful. And thank you so much for inviting the court to present this today. Judge Grigors, appreciate you and your team and all of your folks, the judges and the lawyers that have come out to support us too. I wanted to take just a second to introduce who the court is. I'm Chief Justice Sarah Stewart, and I'm going to go in order of seniority, and they're just going to raise their hands so you have an idea who they are. So next we have Justice Greg Shaw, Justice Kelly Wise, Justice Tommy Bryan, Justice Will Sellers, and Justice Brad Mendham, and Justice Greg Cook, and Justice Chris McCool, and Justice Bill Lewis. We also have helping us today is, of course, the Marshal and his staff, and we are also very appreciative of all of the security force from the university. It's nice to meet you, Chief, last night. And we also, of course, have our clerk, Megan Rodebeck, fabulous staff that do such a good job putting all of this together. So, Madam Clerk, would you call the case?
In case number SC 2025-0172, ex parte John Mason Grimes. In case number SC 2025-0279, ex parte Brooklyn Paige Grimes. Both cases are petitions for writ of habeas corpus originating from the Blount Circuit Court. Arguing for the petitioners, the Honorable Alicia McKay and the Honorable Richard Jaffe. And arguing for the respondents, the Honorable Robert Overing and the Honorable Pamela Casey.
All right. Is everybody ready, counselors? All right. You can begin.
Good morning, Chief Justice, and may it please the court. Alicia McKay alongside co-counsel Richard Jaffe for the petitioners. Central to the petition this morning are the standards a trial court must apply to make a bond determination in a capital case. My focus this morning is on the role that an indictment should play, with the hope that this court will conclude that an indictment standing alone is not enough, especially in light of a case like the one we have before us, where the defense put on evidence to refute guilt. Co-counsel will then address the question, very related, of course, to whether the petitioners are entitled to a bond in this case based on the evidence produced. Now, determining these proper standards requires consideration of the origin of the principle that an indictment serves as a strong presumption of guilt. When traced to its origin, this principle unravels, either because it's so unsound that it should be done away with, or because it was never meant to mean that an indictment standing alone could be the sole basis to deny bond in a capital matter when the trial court is faced with evidence from the defense, like we have in this case, where the defendant is refuting guilt. I think the first place to start in the analysis is looking at the constitutional and statutory language. Of course, we have Article 1, Section 16. But important in looking at this language is that there is no distinction between pre-indictment cases and post-indictment cases. We've created throughout the years, or the courts have, a standard that usually treats post-indictment cases differently. There's some variations along the way in the law, but Article 1, Section 16 doesn't make that distinction. It uses the phrase before conviction. Very similarly, when we look at 1513(3)(a), of course, the legislature has then given courts a bit more guidance in how to make these determinations. But the legislative language made no distinction between pre- and post-indictment cases. Instead, the language chosen is looking at someone charged with a capital offense. It goes on.
Counselor, don't
Yeah.
you think that precedent has established that?
In terms of the role of the indictment? Yes, I think for the most part, we have a cohesive body of law. I think there are some variations in the tests and the ways that the indictment has been used throughout the years. But I think I would turn first to answer your question, and it may be a lengthy answer, but I would turn first to Vaughan. That's sort of where this principle really arose from. That's an 1870 case, which indicated that indictments are strong presumption of guilt in these purposes. But when we look at Vaughan and where this principle comes from, Vaughan is an extremely factually distinct case. In Vaughan, it's very brief as well, but what we can draw from it is that the defendant put on no evidence in that case. So the state rested on the indictment, the defendant put forth no evidence, and in fact, the trial court also had before it not just the indictment, but also the defendant's admission of guilt. So it makes sense in that context that we are relying on the indictment alone. I think from Vaughan, then this principle is adopted over the course of over 150 years, absolutely.
Counsel, can I ask you something
Yes, sir.
about that, though? There was a fundamental change in the statutory and constitutional language under Anais, correct? Yes. Okay, so are we talking about, I think the question here, is it not, is whether that case law survives changes in the constitutional and statutory language. Is that correct?
I think that this court does have a bit of a blank slate to work from because of some of the changes. Now, the primary change is the removal. There's several changes, but one significant change was in the 2022 amendment of Article 1, Section 16, that removed that the proof is evident, the presumption great. Now, in my estimation, the proof is evident, presumption great really went to the burden that the case law was constantly sort of trying to distill for practitioners. That burden language is separate in sort of the petitioner's position from the notion of how the indictment is to be treated.
Okay, so, but also there was also a change from the old language of Section 16 where it said that bail may be denied or cannot be admitted. The defendant cannot be admitted to bail if he is guilty of the offense in the degree punished capitally. And now the current version of that says just if the judge believes that he's guilty. Is that correct? I mean, I guess that's actually the statutory language building on Section 16, but that's a fundamental change too, is it not?
I would agree with that. I think that, again, this court has a little bit of a blank slate to look at. I don't think we can discard all of the case law interpreting these code sections previously or similar code sections because they have evolved and changed some. But even when we look back to a case that we sort of rely on our petition in Ex parte Bryant, the court way back in 1859 looked at a code section quite similar to 1513(3)A. They looked at Section 3669, which indicated that a defendant cannot be admitted to bail in cases, like you were saying, Justice, that may be punishable with death. But again, it has that language where the court or magistrate is of the opinion of the evidence that the defendant is guilty in the degree punishable capitally. So we have had some of that language fall away, but at the core of that, we still have trial courts being instructed to weigh something. And I think that's what the question before the court is. How does the trial court conduct this weighing to formulate an opinion as to guilt, not considering potentially what the ultimate punishment could be in the case? But interestingly, in Bryant, looking at what the petitioners would put forth is similar but somewhat different language, still indicated that the bond issue needed to be heard de novo with some amount of evidence before the trial court to really be able to undergo a weighing, not just the indictment. Now, I think that from Bryant, the state takes the position, if I understand it correctly, that cases after that sort of clarify the role that the indictment plays. And in Hammock, a case from 1885, I think that there's an important distinction or nuance in the law that has really been lost as we've continued to apply this presumption from the indictment. So Hammock certainly contains the indication that an indictment is a prima facie case of guilt in the highest degree. There's no doubt about that. But the next sentence is quite important on page 416. It says, "This, however, is but a presumption in the absence of all other proof." I think what that indicates is that when the state may rest on an indictment, but when the defense puts on strong evidence to refute guilt, there has to be something more than the indictment for the court to actually weigh that evidence against.
Okay, but who weighs the evidence? I mean, doesn't the trial judge weigh the evidence?
Absolutely, yes.
So isn't this really a question of a trial judge's discretion?
There's absolutely the legal standards, and this court's looking at the legal standards, of course, would be a de novo determination. Does this statutory changes, the constitutional amendment, change the analysis in any way? But you're absolutely right, Justice, that this is a discretionary look back on the circuit court's decision in terms of whether the defendants met their burden at the bond hearing. We would just suggest in looking at this, in looking at cases like Hammock, that it's a very unworkable sort of weighing that can take place when the trial court is forced with hearing a body of evidence that the defense puts on to refute guilt. Then they have to weigh that against an indictment, which does not put forth what the state's case is. In Hammock, the court indicated once the defense put on their evidence, it's not also the defense's burden to put on the state's evidence. So we really have a system where the defense is refuting an unknown something, right? There's an indictment, a grand jury has found probable cause, but how is a trial court to really engage in a weighing in that circumstance? Deaver.
So what role would you assign, what weight or what role does the indictment play in the weighing process? Is there no place for it, or is there some place? What's your?
I think there absolutely can be a place for the indictment, but I think drawing from Hammock, some of these earlier cases, Deaver is another from the Court of Appeals in 1931, where if the indictment is valid, the state may choose to rest upon it, but in the face of defense evidence, there has to be something more.
Is this sort of a due process argument that you're making?
I think that due process is absolutely, we haven't sort of attacked this straightforward with making a due process, but I think that, yes, Your Honor, that absolutely plays a role, because if the defendants in this case sort of cannot overcome this presumption, it would be an extraordinarily rare case, in my estimation, where a defendant could get a bond in a capital case. And we know that it's not the norm. We understand that that is not the norm. And I see my red lights on. Thank you.
You can finish your sentence, but also Justice Shaw has a question.
Absolutely. We know it's not the norm to grant bonds in capital cases, but there has to be a workable process where those defendants who refute guilt have a meaningful way to obtain a bond.
Counsel, you mentioned that evidence was put on by the defendant.
Yes.
Were all the inferences to be made from that evidence favorable to the defendant?
I think the state is going to certainly point to certain aspects of the evidence. Absolutely. That it believes sort of weighs against that. I think looking at all of the circumstances, and of course, when we look at an intent determination, it's rarely shown by direct evidence. We have to look at all of the evidence, all of the circumstances, and the overwhelming evidence points to a lack of intent to kill by withholding food or withholding medical treatment.
So you would argue that this is a abuse of discretion standard, and your argument is that all of the evidence as presented would indicate an abuse of discretion on the part of this trial judge.
Yes, that's precisely our position.
May I? Go ahead.
But you understand, the statute clearly says that the trial court is of the opinion. And the trial court is in the best position to determine the credibility of the witnesses. Here, it may be when you couple the indictment and a trial court judge may not have believed the witnesses. And so we look to the statute and to the terms of the statute.
Yes, and this is not to say that we are under an easy review standard. Absolutely. We see discretionary review standards used in all sorts of contexts, but that doesn't mean that it is an absolutely ironclad ruling. We don't have specific factual findings in the circuit court's order to be able to point this court to a specific, disagreement with any particular factual findings. But in the course of looking at numerous cases over the course of the last 150 years, this court has frequently looked at the evidence, not reweighed it, but made sure that the discretionary determination can stand in these cases.
Thank you.
Could I? Thank you. So I'm trying to understand the burden of proof here. So 1513(3) says the judge is of the opinion that the accused is guilty on the evidence presented, right?
Yes.
And the judge here said something different than that. He said that he had decided that the Grimeses could be convicted and a verdict against them could be sustained by the jury. So I'm looking at the statute that seems to say the judge is supposed to make the decision. And I'm looking at the standard that the judge applied as being, well, the jury could make the decision that way. So I don't see that as consistent with the statute. And so I'm trying to understand what burden of proof the judge is supposed to apply in 1513(3) when he says, I'm of the opinion they're guilty. Is that preponderance of the evidence? Is that a jury could convict them? Is that that they're guilty by beyond a reasonable doubt? What is the burden of proof that the judge is supposed to apply when he applies a text? And I'm a textualist, the text of 1513(3.
Right. I think, unfortunately, the text does not give us a lot of guidance on what the burden should be. The trial court pulled from Rodham and some similar cases that use that could language. I would have to agree with your analysis that that is not delineated in any of our language here. So we're not sort of married to that could determine or could a jury do this, because it is the factual finding of the trial court. Now, the burden language used to be in Article 1, Section 16. It was sort of this phrase, when the proof is evident or the presumption great. And our case law tried to sort of distill that down into a burden that courts are a little bit more familiar with. What does that mean exactly? That language was removed, and we don't have any indication from the legislature of what the burden should be at this point in time. There has to be a formulation of an opinion. But I would suggest to the court that there has to be something more than probable cause, because if otherwise, once we have an indictment, there's no reason then to have any process under 1513(3)(a. So we know it has to be more than probable cause. I don't think we can go so far as beyond a reasonable doubt. I don't think that that's something that's supported necessarily by the language, because then why would we have a trial? So I do think that this court will have to grapple with where the standard falls without a lot of guidance from the legislature, with that removal of the prior burden, and somewhere.
I see a preponderance of the evidence as somewhere in between those two spectrums. So you would be asking us to remand the case to the trial judge for him to apply preponderance of the evidence standard on the evidence presented to him.
I think it could fall somewhere closer to a clear and convincing burden. There are some other state...
On you or on the state?
That's another question. I think that...
You got to tell us. We don't... You're the advocate.
Sure. If the indictment standing alone, if that is left alone from the case law and not done away with, then the burden, it becomes a rebuttable presumption, I think the burden then has to fall on the defendant. If that indictment is strong evidence of guilt is sort of reworked and reconsidered by this court, there is support in sort of other state court. Florida is one that has relooked at this issue and placed the burden on the state. So there are cases on both sides, and I know that that's just persuasive, but there are cases on both sides that have drawn from the notion that there is a presumption of innocence, that the grand jury does have an important role, but it's not to foreclose bond, and have placed the burden on the state. So if the burden is on the state, then preponderance of the evidence could be an appropriate sort of burden, and that would be coming from, there's an Indiana case in that regard. So I know that's not the most direct answer, but
Thank you.
Yeah.
Thank you, Ms. McKay.
Thank you.
You sit down. Madam Clerk, if you will add her extra time to your side. Mr. Jaffe.
May it please the court, Richard Jaffe on behalf of petitioners. This case presents the perfect example of why an indictment alone is not enough to deny bond. When the defense puts on powerful, unrebutted evidence that negates intent. Based on the evidence, the element of particularized intent necessary to sustain a conviction in a capital case is so lacking in this case that petitioners are entitled to a reasonable bond. The legislature could have said no bond in 1513.3. They didn't. We know that it's a rebuttable presumption. There are questions of burden of proof. Whose is it? What's the standard? The trial judge in this case said it was clear and convincing. When I asked him in the record, but before he said there has to be no way a jury could find guilt. But when I asked him, he said clear and convincing. The defense called the state's pathologist, Dr. Jeruka Malone, reviewed 7,000 pages over a 6-month period and concluded that the cause of death to be malnutrition due to complications from multiple genetic abnormalities and the manner of death to be undetermined. And that's the state's pathologist.
Mr. Can I ask you a quick question?
Sure. Yes, sir.
I ask your co-counsel, is it your position that the inferences to be drawn from the evidence are all favorable to the defendant?
Yes.
My understanding from reading this is that the child was not taken for medical treatment for a considerable period of time. Do any of your experts rebut that?
Yes. In this sense, there were two experts, the state's pathologist and Dr. Coghill, the head of neonatology at UAB. Both of them found no particularized intent to kill this child, and that the death was the genetic factors that were so severe that malnutrition occurred because the feeding tube wouldn't stay in. And Dr. Coghill testified that 2 doctors couldn't have done this, raising this child, because you can't tell when the feeding tube is out. We do know that the feeding tube was always in, and there was constantly food in the feeding tube. So we know from the inferences from both experts, to answer your question, Justice Shaw, from both experts, that all of the inferences point towards the defense. The state, and I think it's telling that the trial judge did not discuss any facts. One of the justices asked about the burden of proof and abuse of discretion. There has to be some standard. It can't be unfettered, or we would have no bond in any case. So it has to be some type of abuse of discretion. And in this case, when the state puts on no evidence, zero, none, and the cross-examinations did not produce any evidence rebutting our presumptions that you suggest.
Is there any explanation for why the child was, I won't use the word thriving, but the child was surviving as long as he was receiving constant medical care. And then there was a drop-off in medical care, and the child does not thrive and dies. Now, if a trial judge is sitting there listening to all of this evidence, I'm not even talking about the indictment right now. I'm just talking about the evidence you presented. It's your position that this trial judge has no leeway whatsoever to make an inference that the child's death could have been the result of a lack of medical care?
I think that's right in this sense. The word no leeway, I'm not sure that I would put it that way, Justice Shaw, but I would put it this way, that once the defense puts on powerful evidence suggesting that there's zero particularized intent, there could be an inference, looking at it in the best light for the state, of maybe it was negligence, maybe it was some recklessness, but not particularized intent. And that's why it's so important that evidence we put on needed to be rebutted, because you have to look at the totality of the care given. And the totality of the care was, even the DHR workers said they'd never seen any care ever that was given so adequately and so lovingly as the Grimes did to this child. And so there's got to be a context for the judge to find that the evidence adduced shows guilt. And if there's no evidence, and there was no cross-examination attacking the credibility of either witness, one of which is the state's, so there was no attack on what the witnesses said or the witness's credibility, which could explain why the trial judge never mentioned anything. Oh, my red light is on. Never mentioned anything about the facts. Anything about either witness was not in the order.
Thank you, Mr. Jeffy.
Thank you.
Thank you very much.
Now, Mr. Overing.
Mr. Over, I'm just going to interrupt you right off the bat.
Okay. And if he didn't, I was, so that.
I think we're in agreement. There is no right under the Alabama Constitution to bond in a capital case.
That's right.
That's correct. And that's pursuant to the amendment in the 22 Constitution.
Right.
Okay. However, it does appear that the legislature left the door open for a bond in a capital case by virtue of statute 1513. And that statute says a defendant is not eligible for bail when he or she is charged with capital murder pursuant to section 13A540 if the court is of the opinion on the evidence adduced that he or she is guilty of the offense. I think by implication there, the door is open for bond, provided the trial judge is of the opinion on the evidence adduced that he or she is not guilty of the offense. Would that be your understanding of it?
That's right.
Okay. Could you take us through the state's position on the effect of the indictment, the burden of proof here, and in response to what Justice Cook had asked, what do you think the level of proof is necessary here? And what I'm really trying to get at is, it appears to me that based upon the Constitution and based upon the way that the legislature has worded this, there doesn't seem to be a lot of push from the law for there to be bond for a capital defendant. The Constitution doesn't protect it. This way this statute is worded, it leaves it into apparently the discretion of the trial judge. So I'm trying to understand, are we going to have a mini trial at the bond stage between the stage where a grand jury has already been presented evidence, has returned a true bill, and before we get to the petit jury, where we're going to make an actual finding of guilt based on beyond a reasonable doubt standard, we are in the middle at a bond hearing. We already know what the Constitution says and we know what the statute says. So at that point where it says, on the evidence adduced, so that tells me there must be some evidence adduced or there is no bond. Would that be correct? So we have evidence adduced. Who presents that evidence first?
And I'm going to add to that, if you can fit all of that into something, because I would like you to discuss about whether there is a shift of the burden once the defendant has presented on rebuttable evidence of the indictment.
And you could layer on top of that, is an indictment evidence adduced?
Got all that, Mr. Overing?
May it please the court.
I hope it does.
So I'd like to start with this worry about a mini trial, which is a real concern of the state, that putting on evidence, having to prove the case, not just before the grand jury, not just at trial, but then this interim period for pretrial detention would be a serious burden on the prosecution. It could jeopardize witnesses. The prosecution will have an impossible choice to make of which evidence to put on or which evidence to withhold, and how much the prosecution's willing to risk if this person walks free in the interim. And really, the proposal is not just a mini trial, but one that is an even higher burden in capital cases. If I'm hearing the other side right, it could be a preponderance of the evidence. It could be clear and convincing evidence. I think below they argued it should be beyond a reasonable doubt standard, which would be even higher than in a non-capital case. In a non-capital case, you consider all kinds of other factors like flight risk, danger to the community, and the state is not put as a necessary burden to prove its case to some degree of specificity, some quantum of proof. And so this would be a novel.
That brings up another issue. The second part of the new statutory language is there's a framework that's involved in that. There's no such framework with capital cases.
That's right. And so if I could focus on the text for a moment, I think the legislature well knew how to put the burden on the prosecution and say, you must prove XYZ by clear and convincing evidence, and didn't do that. I think the text should be read in the context of the common law. There's a canon, a presumption against the derogation of the common law. And so the text shouldn't be read as doing something new when the people, the legislature, have known for 150 years that there is a heavy presumption against bond in a capital case when a grand jury has found evidence that the defendant has committed an offense of such gravity. The law automatically deems him to be a danger to public safety and a risk to flee from justice. Now, that can be overcome as a matter of legislative grace. The legislature has provided this rare, extraordinary exception to the general rule. And the presumption...
And you would agree with me that this is not the ordinary case, right? I mean, this is unusual.
The facts of this case?
They are.
I think this is an ordinary case in the sense that you could have the defendant come in and provide some evidence that may or may not be exculpatory.
Bond hearing went for 200 pages. That 2 days, 3 days of bond hearing? You don't think this case with expert witnesses and so on is an unusual case, not a usual case of people in gangs shooting each other in the street?
Well, and I think the court should absolutely have those types of cases in mind when setting a rule for.
And I do. I'm very concerned if we set a rule here that we risk public safety. But this case is unusual.
This is a decision for the trial court to make in the exercise of its discretion.
But not if the trial court used the wrong legal standard in exercising its discretion.
And I don't think that is obvious from the words used in the order. Of course, the court was drawing on precedent using the words that a jury could sustain a conviction on this evidence. And I think that's another way of saying there is a heavy presumption. If the presumption were so easy to defeat that all the defendant has to do is come and put on some evidence of any kind, it doesn't have to be expert evidence on their rule. It could be any witness. It could be as much as the defendant saying, no, I'm not guilty. Does that count as evidence? And then the burden flips back on the state. That's not much of a presumption at all. This is just how a presumption works, that there is a hurdle that has to be cleared.
But that didn't happen in this case. So let's not confuse it. That didn't happen in this case. They put on a case, and there was no response from the state. Am I correct?
Well, there was evidence from the state. There were photographs put on. There's the autopsy report that's in the record is great evidence for the state, and there's testimony elicited on cross-examination. So as a formal matter, the state rested because it doesn't have to do anything when there's a presumption in its favor, but there is evidence in the record to support the state's position. So I don't think it's right for them to repeat over and over the state had no evidence. How about Dr. Malone's testimony that the evidence at autopsy was that this child had suffered for more than a few weeks of starvation on page 154 of the transcript? I think that's pretty darn good evidence for the state, and if there could be multiple inferences drawn from this record, then it's well within the ken of the trial court to draw those inferences. And this court has no way to manage the standard they're proposing because trial judges are not going to write detailed factual findings on the preponderance of the evidence at a bond hearing. For obvious concerns about pretrial publicity and impartiality, it's completely unworkable.
Mr. Overing, let me ask you a question because I know we're talking about the facts and I get that's obviously the trial court's dealing with that, and we leave that to the trial court to determine what the facts are. In cases, but the presumption from the indictment, the presumption of guilt for purposes of denial of bond, based on the finding of an indictment, that's really what we're here to figure out if that presumption survives the change in the statutory and constitutional language of a Nyes law. And I'd like to know your opinion on that. What is that? Did it survive? We've gone. It's a pretty big change. So have we gone from the previous case law basically being abrogated by the legislature's passage of a Nyes law and the adoption of the constitutional amendment, or are we still operating under that same case law?
I think, if anything, the amendment favors the state because it took out that kind of vague and antiquated language of proof evident or a presumption. Now, I think it's important for reading the statute that it's an or in the Constitution. Mm-hmm. It's either evident proof or a great presumption, and that suggests that the indictment is doing the work of creating that presumption. When you're in a world where there is evidence, then you might have a question of what that standard could be and how it might overcome the presumption, but the text of the statute did nothing to abrogate the common law rule that everyone's known for 150 years. And so I do think
it did change from I believe the previous language said that the defendant cannot be admitted to bail under 1513(3) cannot be admitted to bail if the court is of the opinion that he is guilty of the offense in the degree punishable capitally. And under the current version, that degree of the offense. So I guess arguably it's a lower standard now. It's an easier standard for the court instead of having to prove that they would actually get the death penalty. Is that a fair statement?
I think that's fair. We haven't delved into the legislative history there. Of course, the court knows that there were all of these debates about classifying which crimes are capital. If a crime could have a life sentence, could that be a capital case? And as the U.S. Supreme Court has said more and more that certain crimes can't be punished capitally, are those still ones for which bail is not a matter of right? And I think that language goes to that there are other charges that may not be bailable and are still treated as capital, even if they won't, we all know, be punished with the death penalty because of other precedent or other changes in the law. But I think the court should take the traditional rule, the old soil, to interpret the new. because it coheres with the structure of our criminal justice system, and because it's just withstood the test of time for 150 years. The first sentence of their habeas petition says it all, that this rule has been in the case law since 1870. Not only that, but the presumption of guilt has been replete in our more recent case law. That's the petition at page 20. And they're right about that. We've cited Vaughn, Rear, Hammock, Robinson, and then even recently, cases like Wilding, Patel.
Mr. Overy, if I can, along the same line, I've been curious. I understand the state definitely agrees with the ultimate conclusion that the trial court raised, but we're being asked by the defendants to find error. Do you have disagreements or any error in the legal conclusions? I don't know if you call it purported burden shifting or how the trial court tried to deal with the legal issue of how it reached this conclusion.
Well, we think that the court was overly generous in permitting a record to be developed to this degree. I think the defendants got to make some proffer that warrants such expansive evidentiary.
But do you disagree with how the trial court treated the legal issues, basically relying on the 100+ years of case law?
No, we don't. And
so it should remain the same even under the current scheme.
Well, I think the court could say that the change in the language to move from that exception of evident proof or great presumption, to remove that language, has strengthened the state's case.
But that would be the state's argument for us. I mean, I realize we can sort of handle it, but what's the state's position on how we should we do nothing? We just affirm, like the Court of Criminal Appeals basically just said, this has always been the law of this state, period, end of sentence, go to the Supreme Court. Or do we need to change it, tweak it, add to it, subtract from this old law?
This court can resolve the case in a paragraph, citing some of the cases that I just named.
Would that be the state's position?
Yes.
Okay.
And the court does not lightly overrule precedent. I think we've named probably a dozen cases that contain this rule. Petitioners, perhaps no one knows how many cases have actually applied this rule, and they've got to state with particularity which of the cases they want overruled. And then they've got to grapple with the weight of stare decisis, which they haven't done. For example,
you would agree with me that some of these cases have language in them that seems, how should I put it, contradictory? I'm looking at the Wilding case and the State v. Moyer case, and I'll just quote Wilding, which is one of our most recent cases on this, and it says, quote, "The state has the burden of proving that the crime was committed and showing facts that would convince the judge that upon final trial, the judge would sustain a verdict." So that language seems inconsistent with what the trial judge did here when he said that a jury could reach this verdict.
I'm not sure if Wilding is describing in the part you just read, the pre-indictment case or a post-indictment. And so in Patel,
and I think Moyer repeated this as well.
And Moyer did too, and Hall addresses it as well. There's one test for pre-indictment and one for post-indictment, and those four cases explain the distinction. So Patel applies Trammell because Patel had not been indicted, so there's no presumption of guilt. I mean, that's very clear from Patel.
But there was an indictment in Wilding.
And that's why the presumption applies, and it's a heavy presumption. And I heard from the other side that there's no basis in the text for this, but I think that disjunctive, either the proof is evident in a pre-indictment case, or the presumption is great.
Right, but that language is gone now.
Well, but I think that's a way to make sense of the case law in light of the text. So we have these two types of cases that go to each of those types of exceptions where a capital defendant could possibly get bail.
So now that the text is changed, does that change? Does that?
Well, and I think the DA's Association brief does a good job explaining some of the background and Anaya's law ratified by 80-20 vote statewide. And so I think there's really strong evidence that the people have no problem with this 150-year rule. They keep saying it's unworkable, but then we'd expect to see some evidence, some list of cases that look really sympathetic and where the trial court was, hands were tied and I couldn't do anything because the standard is just too high. And we'd see trial judges calling out and saying, this law is unworkable. We need something better. We don't see that.
Counsel, can I?
I'm sorry. Go ahead.
Like Justice Cook, I am somewhat of a textualist myself. That's where I usually start. I want to go back to 1513.3a. Let's just take out the over 100 years of case law.
I don't want to.
Let's just take it out. Walk me through a bond hearing based on the plain language of that statute. If the court is of the opinion on the evidence adduced that he or she is guilty of the offense, just walk me through the bond hearing and tell me what would happen.
Well, I think the text is ambiguous when it says evidence adduced. Evidence adduced by whom? When there is evidence from the defendant, does it overcome the presumption? I think is a perfectly sensible way.
What presumption? I'm not. No case law. Just walk me through what presumption.
If there's no case law, the court will look to the history of the common law and the English history, and will find a presumption.
Does the indictment create a presumption?
Yes, and the English law was that the indictment, because of the centrality of the grand jury in that system, was conclusive in capital cases. And we don't go back and allow the trial judge to override, to peek behind the indictment, to see what evidence was there. There's no option for the defendant.
But the trial judge is not dismissing the indictment here. He's just deciding whether there's going to be bail, right?
If the trial judge is deciding whether there's probable cause as to the defendant's guilt, he or she is redeciding the ultimate issue of guilt, which the grand jury already
Which the legislature told the trial judge to do. Trial judge was instructed to look at the evidence adduced, right?
Well, in light of the fact that there's a heavy presumption, we don't want this happening in the routine case, and that's what the rule would lead to. Is that in every case, every capital defendant would be creating a collateral proceeding that would delay trial for months. This case should be going to trial now.
Well, let me ask this question. These folks have been in jail a year now, right?
That's right.
How long is it going to be before the trial?
Well, I don't know. You have to ask the DA.
I will. I will ask her that question. Back to the question. I'm trying to understand, and I think Justice Shaw has asked a really good question, like how this really works. Okay, right. If there's they've introduced 200 pages of expert testimony and DHR testimony, and then you have the presumption from the case law from the indictment. But the judge doesn't know what happened in the grand jury. The judge doesn't know the evidence. So how is the judge supposed to weigh something he doesn't know against the actual evidence that got introduced?
Right. And I think that's why the presumption has to be very strong, because otherwise the case...
It can't be irrebuttable, though.
It has to be a rare and extraordinary case in which that presumption is overcome. Yes, and it has to be based on the trial judge's discretion, because it's almost unreviewable from this court without factual findings and without the state presenting its case. Let me make another textual point that may help you. That provision is entirely negative. It says that bail may be denied or ineligible for bail if the court is of the opinion that the defendant is guilty. It doesn't create that converse right that if the defendant proves his innocence, then there's a constitutional right to bail or an automatic entitlement to bail of any kind. And so I don't think the legislature should be read to have expanded bail when, in light of 150 years of history and the recent statutory changes, all evidence suggests that the people in the legislature did not want that result.
Mr. Obring, I have a question for you, if I could, Chief. Before you sit down, I don't think anybody's intimating that there's some kind of right, something that's changed. Actually, I think you are correct. It says this is restriction on bail. However, let me just ask this, because the question's been asked. What does it look like now? Okay. And I can only call on experience I've had when I was a prosecutor. Some of you know that if there was a bail bond hearing, then we as the state would put on evidence to some extent, not the full case, but to some extent, showing the facts of the case that would underlie the grand jury's indictment. Okay, and then the defense would sometimes put on evidence, sometimes not, but most of the time put on some kind of a case, and then the judge would decide based on that evidence. And I'm reading here; it says, if a defendant is not eligible for bail under the current law, under 15-13-3A, if the court is of the opinion on the evidence adduced, okay, that he or she is guilty of the offense. And I guess my question goes back to how does the presumption of the indictment play into that? I'm not saying that there's the court, what can the court consider? But it almost sounds like an irrebuttable presumption that you're talking about, and I think answer that.
It is common for the prosecution to provide some kind of proffer of here's what was presented or here's what will be presented at trial, and that can go to the factors like the danger to the public or the likelihood of a flight risk.
Now, I'm sorry to interrupt you, but under the code sections as I see it here, under subsection B, flight risk, likelihood of flight risk, danger to the public, all that kind of thing is relevant. It's not relevant in a case involving capital murder. There's a difference. Would you agree that the legislature has made between capital murder charges and all these other charges that now are potentially eligible for no bail under an IAS law?
That's right, and that's why I don't think that the proffer is necessary in a capital case. And that's how a presumption works. I mean, imagine if the defendant comes in and says, I want bail, and then the state says nothing, the defendant says nothing. On their rule, does the defendant walk because the state hasn't carried its burden by a preponderance or a clear and convincing evidence or beyond a reasonable doubt, whatever it may be?
But that's not what we're dealing with here. And I am still trying to get to, I'm sorry, I'm still trying to get to what happens in a case based on the statute, based on 1513-3A in particular, when the defendant has overcome the presumption of guilt. Does the burden then shift back to the state?
If this defendant overcomes the presumption of guilt arising from the indictment, then the state could then engage with the defendant's evidence. Yes, I think that is how it would work. I don't know what the rules for such a hearing would be in terms of is there a subpoena power? Are there witnesses? Or is there hearsay evidence allowed? What would the rules for that proceeding look like? We don't have a whole lot of answers to suggest that this would be workable. I know other states have done it, but we don't have that history in Alabama, and absent some strong reason to think that we need to start from scratch, this court shouldn't.
So this statute is not ambiguous to you, based on what you've just said?
I think that's one way to resolve the ambiguity, yes.
Thank you.
All right. Thank you, Mr. Overing.
Thank you.
So add that time to Ms. McKay, but Ms. Casey.
Madam Chief Justice, may it please the court, I want to start by addressing some of the questions that have been asked by the justices to get a clear understanding. First,
I don't think you have 45 minutes.
Okay. Well, I'm going to go quick. I'm a fast talker. Justice Cook, this is not an unusual case. This is a capital murder case in which specific intent to kill is present. If you look at the record under Exhibit 8 of the bond hearing transcript, and the question was asked of the defense expert, is feeding a child an intentional act based on your training and experience? Answer, well, they can't do it themselves, so that would be an intentional act. Yes. Is making the decision not to feed a child an intentional act? If you decide not to feed them, yes. This is not an unusual case, whether you have gang violence of shooting in the street or you have a foster family that decides not to feed a child. That is an intentional murder. That falls under Alabama's capital murder statute. Now I'd like to come to Justice McCool's question about whether or not this case law survives. We are not in an environment where we can forget 150 years of our precedent. Number one, if you look at the statute 1513-3 and you look at the changes that were made prior to. The only changes that were changed, the adduced language wasn't changed in that statute. So we don't throw away how this court has interpreted the adduce.
So you would agree with me, though, that there is the ability, if the legislature comes in and abrogates, they're presumed to know what the case law is. Okay, so if the legislature comes in and changes it, they can change that case law. We can move away from it. So you agree with that, correct?
Correct, Your Honor.
But
Justice.
But if so, is your argument then that they just didn't do that in this case?
That's correct.
Okay.
Now, let me address something that Justice Wise, that you asked the question about whether under 1513.3, if you look at B1, which does not apply to this case, but if you look in that statute, there's a reference to the presentment of the indictment or evidence. None of that is referenced in 1513.3A, which means had the legislature intended that the state put on evidence, that would have been put in there. They made changes to 13.3A. Had they chosen to put forth the language of the presenting indictment or evidence by the state, they would have done so. They did not do so in this case, and therefore, this court's precedent of over 150 years should stand. I would like to talk just a little bit about if you change the standard where the state has to put on evidence, and I disagree with Mr. Jaffe's proportion that this was powerful evidence. It wasn't powerful. If you don't feed a child, I don't have to put on evidence as the DA to put on my evidence when I cross-examine and get out the fact that the child wasn't being fed. And if we look at the trial court, look at the...
It's a little more complicated than that, wasn't it? I read the 200-page bond transcript, and the doctor said that this was a feeding tube, that you would put the food in the feeding tube, that apparently all the evidence was that the feeding tube had food in it all the time. You just couldn't tell the feeding tube had come out of the small intestines because the feeding tube had to go all the way through the stomach, or else everything would be spit up. So it's not a question of not feeding the child. It's a question of whether they correctly used the feeding tube because it had been dislodged.
And I'll disagree with you for just a second on that, Justice, because there was a discussion in the bond hearing with Dr. Coghill about whether or not this tube would have stayed in the proper place. And I thought I had brought it up here, but I'm going to tell you that it's on part of the Exhibit 8, page 184. That doctor, their own expert, said this tube wouldn't have stayed in 2 or 3 days, which goes back to the point of what Justice Shaw was saying about the inferences. And it goes back to what our trial court did on page... Right,
and then I don't mean to be arguing with you about whether or not these people are guilty or not, because I just can't do that. I'm an appellate judge. I can't, I wasn't there. I didn't talk to these people. I can't make those factual determinations. But what I can say is whether there were competing inferences to be made, and if so, did the judge use the right legal standard in dealing with those competing inferences?
So I don't think there were competing inferences. The judge actually goes back on page 220, and he specifically asks the expert. So this tells me this judge was actually attempting to figure out he was inquiring into facts, and he's pretty much said, what should these people have done when that tube came out? And the answer the doctor said was, if the tube comes out, there's only one thing you can do. Go back to the hospital and have it put in. We know from the record...
There should have been a heightened standard for these defendants because they knew this child had previously been diagnosed with failure to thrive.
Absolutely. And the record reflects that every time that this child was actually in the hospital, it thrived, it did well, it gained weight. When the child went home with the defendants in this case, it lost weight, almost to 40% of its weight between the September 25th of 23 until November 22 of 23. Never saw the doctor. And their own experts said that during that time, that tube would not have stayed in more than 2 days at a time and would have had to return back to the hospital.
Was there any evidence they were told that they could only keep the child at home for 2 days and they have to take it back to the hospital after every 2 days?
No, there was evidence in the record that showed that they had done that previously, that they were taking
every 2 days.
Well, every time they claimed it came out that they were taking it back to the ER. But once they determined that the child had some type of potential genetic issues, the child never goes back to the doctor. The child loses almost 40% of its weight. And there's no evidence based on the state's expert. It was malnourished for weeks at a time.
So answer the question I asked the Attorney General's office. They've been in jail a year now, right?
I would start this case Monday if defense counsel would show up at the courthouse ready to pick a jury.
Is there a trial date?
There is, and they asked for a later date. The trial date is March of next year, and I believe October of 26. That was put off by defense counsel, not by the state of Alabama, when that was ordered back in December. If you can look at the record, this death happened in November of 2023. We did not indict until the summer. We were available for bond hearing and presented that in December. That was denied in December. We're held up right now because of bond.
I'm not trying to get the background. I just want to know the dates. They've been in jail about a year now, right?
That's correct.
And you're telling me the trial will be in March or in October?
Okay, one defendant's trial will be in March. The other defendant's trial would be in October at the request of defense counsel, not at request of the state. State was ready and willing to try this at any point. Trial court put this down for trial. And it goes back to...
Okay, Ms. Casey,
I'm sorry. I apologize.
All right.
Thank you, Your Honors.
Ms. McKay.
Thank you. I do want to start with this notion that this is an ordinary case. It's not an ordinary case. When we look, and I tried to find cases of capital murders by omission, there are very few indications in the case law that this is an ordinary case. You have to have a particularized intent to kill, and in this case, that is by omission.
Okay, let me ask a question
Absolutely.
there. I don't think that's the issue.
Right.
Ordinary, unordinary case. The only question that's before us, we don't know what the facts are going to turn out to be. We know what's as appellate judges, we know what's in the record, okay, but there's going to be a trial and all. So I want to go back to the question about the presumption. I think your co-counsel, I didn't get a chance to ask him. He said something about a rebuttable presumption. I'm not sure exactly where Mr. Jaffe was headed with that, but what kind of presumption is there going into a bond hearing under the current state of the law? Is there any presumption? Is there no presumption? Is there a presumption in favor of the defendant? Is there a presumption in favor of the state? Because that's really what we're here to decide today.
Right. I think there's no disagreement here that there is no entitlement to bond in a capital case. We have to recognize that as an underlying principle, that it's a rare case where a capital defendant may be able to get a bond. When we talk about, I think there are two diverging pathways that the petitioners have sort of pointed this court in. One is that this notion that the indictment is strong evidence of guilt is not sound and could be undone. There is a way to do that. But we've also argued this morning that looking back at the history, we understand that overturning 150 years of precedent is not an easy pathway. We can also look to cases that recognized a lot more nuance in the law that do say, to your question, that the indictment is a presumption of guilt for a bond purpose, but it's a rebuttable one by the defense. I think our ultimate position here that we've been sort of steering the court to is that once the defense puts on evidence, and we see this in a number of cases, the state has to do more than rest on the indictment for the court.
Not just put on evidence, put on credible evidence that overcomes the presumption of guilt if there is one attached.
That's an important distinction. I'm glad you brought that up. In Wilding, the 2009 case, we see an example of that. The state put the indictment on, that's presumption of guilt. The defense then put on some mitigating evidence. This individual is a strong member of the community, not a flight risk. Well, that doesn't go to guilt, right? So the state in that case can rely on the indictment because the defendant has failed to put on credible evidence towards negating guilt. So this is a small category of cases where defendants will be able to potentially put on evidence to specifically negate guilt. And in those cases, the state has to do something more to allow trial courts to comply with 1513(3)(a) and actually weigh the evidence adduced. There is no way to weigh defense evidence, expert testimony about such a particularized intent to the indictment, which we don't know what it is based upon.
So, counsel, what I'm
It says that they did put on evidence. They cross-examined witnesses, etc.
Certainly there is cross-examination. I wouldn't agree that there was that the defense evidence was refuted in that cross-examination. At one point there were photographs shown to a DHR witness who had no idea what the photographs depicted. I don't think that can be recognized as really refuting the defense evidence. There were inferences, I think, made during cross-examination, but what it amounted to was largely speculation.
But is it not the trial judge's responsibility to determine those inferences?
Certainly that falls on the trial court, but I don't think that the trial court's ultimate determination, while there's a lot of deference that has to be given to the trial court, it's not an unassailable ruling, and certainly there is, and by no fault of the trial court pulled from a number of cases that say things similarly, but don't all use the same standard. I started this off by saying this is an exceptional case, and it's an exceptional case when we look at the history of the cases that sort of talk about indictments being strong presumption of guilt.
Counsel, I think one thing, we piggybacking off of what Justice Breyer and Justice McCool have mentioned, all we do is resolve questions of law. That's all we do. Legal questions. One thing that we do not do is we do not weigh evidence. And so, Justice McCool we've all been zeroing in on these issues that we can resolve. And the issues that we can resolve are the issues dealing with the Niles Law and the modifications in the Alabama Constitution in 2022, and looking at 1513(3)(a). We can look at the text, we can look at the history, we can look at 100 and something years of case law, and we can try to determine what the legislature was doing in making these modifications. Do we retain the case law? Does the case law meld easily with the new language in the statutes? Those are the issues that we can resolve. But we, as an appellate court, we will not reweigh this evidence. So, if you would like to discuss anything further about the mechanics of these statutes, that would be the statute and the Constitution. That would be particularly helpful to me. What I have heard sitting here and from reading all the materials is that we have an indictment and we have evidence, extensive evidence, 200 pages introduced that the trial judge had to consider. We also know that evidence created inferences that can go both ways. And so I'm sitting here looking at this, and I've got a trial judge that has the discretion to look at the entire picture, including the evidence that was introduced favorable to the defendant, and also to look at the inferences that can be drawn from that are not favorable to the defendant. And the trial judge makes a decision. So I guess what I'm trying to convey to you is, I say I've used up all your time. Maybe we'll give you another few minutes. But I don't think it helps us move the ball down the field a lot to talk about ordinary, extraordinary, undisputed evidence, strong case, or whatever. We give a great deal of deference to trial judges in this situation. And so what we're actually here to do, and what we will do, is we will interpret the Constitution in a connection with this statute and try to understand how the mechanics work. Because I just wanted to lay that out there too. I have no question. That was just a speech. I apologize.
I'll ask a question. Did the trial judge reach a conclusion on the evidence adduced that the Grimeses were guilty?
The trial court, I would say yes. Well, in different terms. The trial court said that based on the evidence presented in the hearing, the court is of the opinion that a jury conviction could be sustained. I don't know that reflects the trial court's opinion. It's
Is
difficult.
that the only opinion the trial judge expressed?
That is the ruling is just that one or two sentences at the end of the order. It does not comport with 1513(3)(a) for the judge to make an opinion on the evidence adduced. It's sort
So
of
the judge did not state an opinion in the terms of 1513(3).
I would agree with that. Thank you.
Thank you, Ms. McKay. All right. Anything further? Counselors, we really appreciate your time and the effort that you put in this case. The briefing was excellent, and so were the arguments today. So thank you very much for that. And we will take this case under submission and we'll adjourn.
All rise. Court is now adjourned.